Good morning, everybody. It is Monday, November 27th. Welcome to the Montgomery County Council. This morning, we are taking up a number of items with regards to the upcoming state legislative session in Annapolis. We've been having a series of conversations about local bills, things that we are proposing, things that our senators and delegates are proposing, and today we are continuing that conversation. We are going to start where we left off 2 weeks ago, and that is with the bi-county bills, issues that affect Montgomery County and Prince George's County. I'll also just note there are a number of colleagues. One in particular, I see Councilmember Balcom is joining us via Zoom. I hope you feel better, Councilmember. And I think a few others will be joining us soon. So with that, I'll turn it over to Ms. Wenger and her team to walk us through the packet.
Okay, great. Good morning. So the bills are kind of opposite right now. So if you'll turn to the bill summaries to page 5, those are the summaries for the first bills that we're going to talk to you about on the bi-county level. And these are pieces of legislation that we've not discussed before. And then with time, we'll go back and do the follow-up bills.
Perfect.
The first one is Prince George's County, Montgomery County bill. Kathleen?
Good morning, Mr. President, council members. Just a note about all of these bills in the packet. At the time we met with you, and then later in the week when we met on I think it was November 14th, and then later in the week with the county executive, each of you requested follow-up information on a number of bills. So we've got some of that, but literally I was still getting information over the weekend. So I may reference information that I got over the weekend that's not in your packet, just a note. Okay, on this first bill, PGMC 101, this relates to this was requested by WSSC, and it relates to a program that is currently being implemented by WSSC. So I'm sure you well know that WSSC can only use ratepayer monies for things that are authorized in state statute. And back in 2019, the state authorized WSSC to essentially use ratepayer money to become a bank, for WSSC to become a bank, to provide loans to customers who needed to replace the water service pipes that go from a residence to the street. Each of us are responsible if something happens in those pipes to fix them. And so this authority to create a loan program for that purpose to help with replacement costs for water service pipes was created. There's a history to that. I know Keith Levchenko also knows very well sort of how that came to be, and we could talk about it if you'd like. But the program essentially allows loans of up to $5,000. The state law mandates that WSSC allocate $100,000 each year for the program. There's a cap of $1 million for loans, and the program is underutilized heavily. The memo sort of outlines that it's heavily underutilized. There's only been 6 loans that have been made since the program was created, 5 in Prince George's, 1 in Montgomery County. The total loans less than $30,000 outstanding. So WSSC, it's my understanding, initially began to think about expanding this program eligibility after talking with the plumbers unions, who suggested that the program could be expanded to cover the cost of diagnostic, the cost of figuring out, are your pipes at risk? Is there a problem before it blows up? And also expanding it to cover sewer pipes that go from your house to the street. So the bill expands the program in that way, and it also increases maximum loan to $10,000, requires $200,000 to be allocated each year rather than $100,000, and extends the sunset. The program was scheduled to sunset in 2029, extends for 5 years. So that's what the bill does, again requested by WSSC. I was just trying to see if there's a WSSC rep if you had questions.
Thank you for that debrief, Ms. Boucher. WSSC is something that we've talked a lot about in the last few weeks and months, particularly the T&E committee, as we talked about the guidelines for the potential rate increase. And it was something that we worked with the Prince George's Council and the two executives negotiated. So all four legislative leaders, bodies within the two jurisdictions worked collaboratively to figure out what a potential rate increase is. I share that because WSSC is still trying to figure out a model for their basic services that meet the energy, the water conservation and efficiency levels that are happening throughout our community. And I just have some basic questions, overarching questions, which you will not be able to answer. But if a policy was created a number of years ago that is underutilized, and now they want to double the amount of money to go into a program that then expands the scope, I'm curious as to why they want to move in that direction. I see Mr. Levchenko coming up to the table, who might be able to shed some insight if he has any. Mr. Levchenko?
Yeah, I think there are a couple issues. One that Ms. Boucher mentioned is while it is underutilized, they feel the need is there and that it will get higher as these pipes age over time. Since you can imagine as homes are built in the 60s and 70s and 80s, those homes are now seeing pipes that are 40 or 50 years old. And often homeowners aren't aware that these pipes are their responsibility until there's a problem. So they think there's a pent-up need here that has not been reflected yet. Part of this might be improved by allowing sewer pipes as well as part of this, and some of the other items that Ms. Boucher mentioned. The other thing I will mention, to the degree that funds are not used in this program, they do revert back to WSSC Water's fund balance. So in the end, the dollars, if not used, would not unduly impact WSSC Water over time. But I think they feel there is a need here that will only get greater over time.
Great. Thank you for that explanation. Councilmember Stewart.
Thank you. Thank you, Mr. Levchenko. I do agree with the thoughts on WSSC and about the need. I think my colleague to my right is nodding his head because I don't think people really understand what they're responsible for until it's too late. And so that I would hope if this does move forward, and I would recommend we support this, to include the sewer repair as well and increase the funding, that part of that is WSSC doing more outreach to members of the public because the pipes are aging. People don't know that they are responsible for it. People get letters in the mail, but it's confusing to them about the different services and whether or not they're credible. And I can tell you that when I was mayor in my office now, we are constantly getting questions about, is this something I need to be doing and is this credible? And so I would say that as looking to the future and as the pipes are going to be aging, that we're going to need this more. And I very much appreciate and think it is wise of them to expand this to sewer repair as well. Thank you.
Councilmember Jondo.
Thank you. Do we know from the sponsors any materials what the average cost of replacement is and how that factored into the increase in loan amount?
I don't. Keith, do you, Mr. Levchenko?
I know that's a technical question, but I just
It
thought
does
that-
vary by property.
Okay.
Off the top of my head, I'm thinking it can range from a few $1,000s to $15,000 or $20,000, just depending on the length of pipe you're talking about.
How far
the
you are
street.
from the street.
And
all
also
that.
any complications in terms of finding the pipe, getting to the pipe, the condition of it. So, but it's not a repair that most people just have money sitting around to accommodate, especially if they're not even aware that they have this aging issue.
Absolutely, yeah, and I know I think probably many of us have been in the situation where there's something wrong and you're like crossing your fingers hoping that it's not on your side of the responsibility line, and if you even knew that you had that responsibility. So yeah, I do think we're expecting a especially cold winter, maybe a lot of weather, and the pipes are old, and all this makes sense for many of those reasons. So I think it makes sense to expand it, and this would just broaden the usage and increase the loan amount and put more money in the pot, expecting that there'll be more coming, as I read it.
I think WC's perspective is hoping, right, to help homeowners.
people.
And they have, Councilmember Stewart, to your point, they have briefed, staff has briefed the commission, WSSC, on this, and they fully intend an aggressive outreach because they understand exactly what you just articulated.
Yeah, and it's really, if you think about how big our area, how big their service area is, it's not a lot of money for what these, if you take 15,000 divided by 200,000, you're not helping that many people in the amount. So depending on how much is in there. Okay, so I think we should support it. Thank you.
Thank you. Councilmember Cass.
Thank you very much. I'm also supportive of this. I believe that this goes back, and Mr. Levchenko, you might remember, I think at one point they could do PVC pipes. First off, let me say I am the least handy person you've ever met. So what I'm about to say is by memory and certainly not anything but I believe way back when it was allowed to have PVC pipes. And when they connected, it did, I see some head shaking, yes. So, and when it connected years later, it didn't work. And so then I believe there was a court case involving that, and there was a set amount of time that a homeowner had to come in, and if the thing exploded, they knew that it was a problem. But if it didn't, then they were no longer under that issue. And I think this would be a great help to help the homeowners from the 60s, I guess, is when the PVC was allowed, to get back on track. I can tell you, I had it happen in my house many, many years ago. And at that time, it was a couple $1,000s. So I can imagine what it costs today. They have to dig up your yard. They have to do all of these things. So obviously, this is something that WSSC is doing the right thing by doing this. I'm supportive. Thank you.
Thank you. Vice President Friesen.
Thank you so much. Agree that we should support this. Agree it's a good program, and agree that there are more needs than the expansion probably reflects. Just wanted to also note and essentially double tap the outreach aspect of this. I don't know that most of us were aware of this program to share with our constituents, and we'll just note, as Councilmember Joanda was referencing, I've been out to Tobytown a number of times. One of their main issues is related to the sewer and the exorbitant costs that would have. Whether or not this particular program would work for them, given challenges there and the structure of the program, I think needs to be determined. But having this in the list of options of things that we explore in communities where there are significant needs would be very helpful. I also think that as a function of the county government to work with our partners like WSSC to aggregate these all in one place. And one of the challenges is we have all these different programs from all these different departments and agencies, and there isn't an easy way for a community to identify what available resources there are. And when you add on some of the built-in institutional challenges that many of these communities face, it's even more difficult. So I hope we can advocate to WSSC specifically to do a better job of the outreach that we have all talked about, but I also think there's an opportunity here for county government and working with the executive branch to aggregate all of these different programs into one place for like programs where communities, based on their circumstances, can apply for various funds. But I think we should support this bill, and I think there's work to be done to make sure that it gets implemented in the most advantageous way possible. I'll yield back to you, Mr. President.
Appreciate the comments of my colleagues. Not hearing anyone express any concerns, we'll support this without objection. Great.
Okay, so the next piece of legislation is PGMC 103-24, and this has to do with the Washington Suburban Transit Commission. And the sponsor, who is Delegate Corman, considers it just kind of a cleanup of the statute in this area, as some of this relates to WMATA, the Washington Metropolitan Authority, Transit Authority. And it starts out by making a very subtle change to the circumstances under which the Maryland Department of Transportation Secretary can have a designee represent him on the WMATA, at WMATA meetings. And that also makes a slight change saying that the WSTC commissioner that is the designee, is as a commissioner serving on, at WMATA meetings, can be reappointed. And then it makes another change that's less clarifying, but I think aligns with Delegate Corman's thoughts that this is just kind of cleanup. It would repeal the provision that requires Prince George's County and Montgomery County, the governing boards of each, to approve WSTC's contracts and grants.
Appreciate the new chair of the Environment and Transportation Committee taking note of some of the changes that Governor Moore has made and the makeup of these boards and the representation. And it is technical in nature, as you noted, and without objection, we'll support. So, thank you.
Okay, the next bill, PGMC 11024. First, just a note at the beginning, it was, in talking with the sponsor, it was drafted erroneously. So the way to explain this bill is, as it came in, it would allow the recordation of subdivision plats with the land records, clerk of the circuit court, with only the signature of the planning department, not the Department of Public Services, Department of Permitting Services. Those are the two signatures that are required to file a recordation plat, to file a subdivision plat. As it came in, it would allow the filing and recording with only one signature. That was very concerning to the Department of Permitting Services because the role they play in reviewing subdivision plats is to make sure that any obligations in the right-of-way are legally enforceable, legally valid, because DPS has responsibilities and the county has responsibilities for the extent to which the public right-of-way is affected. So as it came in, DPS was very, very concerned about this. But in talking with the sponsor, this was literally drafted erroneously. It was intended to implement the recommendation of the Montgomery County Development Process Review Work Group relating to digital signatures and maintaining and archiving digital copies of subdivision plats. So she's advised us that we know that she is working with executive staff and planning board staff to redraft amendments that will essentially strike the bill as it exists and implement the recommendation number 2 of the work group. So we do not yet have those amendments. The county executive's position would be that he supports a bill that does conform to the work group's recommendations, but we're waiting to see those final amendments from his perspective. But that's the status.
Thank you for walking us through that. And just to reiterate, PGMC 110-24 was erroneously drafted, right? So this is going to be changed.
It's going to be rewritten, there's no question.
Okay. I'll speak for myself. I see other colleagues have thoughts too, but speaking for myself, I will continue being supportive of any legislative changes that reflect the consensus, the unanimous support of the development work group that was led by Delegate Lopez. The whole point of that work group was to streamline processes, and that means that they're streamlined to make it easier for everybody. And so I look forward to seeing how this is redrafted and with the caveat that it be redrafted to conform with the agreement of that work group. Vice President Friedson.
Thank you, Mr. President. I agree. Happy to support the unanimous consensus of the work group. There are a number of proposals in there. We just have to make sure that the changes actually reflect what the interests of the group were. We had subject matter experts on it, and they worked very hard to come up with consensus. We had representation from the council there. My question is for our intergovernmental relations office, are we in touch with council staff who are part of the work group on these bills to make sure that they reflect the work group's intention, and are those conversations happening?
So I have been in touch with Pam Dunn and let her know exactly all this background and let her know that we're waiting for the amendments. And she was grateful to hear that because she was aware that the bill didn't reflect a work group recommendation either. So she's aware, and as soon as we get the amendments, we'll get them to Pam as well.
Okay, Ms. Dunn's here, it's very important to me. I don't want us to get recommendations that came from a work group that our council staff participated in without our council staff being intimately involved in determining whether or not it reflects the work group's work product. So I just want to make very clear that I don't expect any recommendation to come from OIR that isn't in direct consultation, at least with council staff, and I would expect the other folks like, Park and Planning and others who were part of it. I don't know that it's reasonable to call every single person on the work group, but we do have people who work within the county who are part of the work group. I'm sure the county executive is consulting his own executive branch agencies that overwhelmingly made up that work group, and I would expect at the very least that before the council takes on these issues and makes a determination that we are getting feedback from council staff first and foremost, and also from Park and Planning.
Councilmember Friesen, I absolutely couldn't agree with you more. And yes, Tom Lewis, who was lead for the county executive in the work group, and I've forgotten the name of the planning staff that he's working with, and I have let Ms. Dunn know they're coming. I will do everything I can to make sure, to see if we can get Ms. Dunn's approval of the amendments before they're finalized by the sponsor. I'll see if we can,
I would
I'll see if we
strongly
can do
recommend
that.
that before
Yeah.
we decide whether or not we think it reflects
Yeah.
the work group's efforts, that Ms. Dunn, on behalf of the council, provide feedback on that. And, I have great respect. I've known Tom Lewis for a very long time, but I'd rather not take his word for his conversations with Park and Planning without our own council staff that was part of these efforts being part of that. So
Yeah.
appreciate that. Hopefully we get nods from Ms. Dunn. I won't ask her to come up to the table, but I just want to make sure that that is absolutely the expectation that I would have, and I imagine that would be shared by colleagues. I'll yield back to you, Mr. President.
Appreciate you recognizing our own staff that were part of those conversations, and should be a check to make sure that the legislation that's being proposed in Annapolis properly reflects that. Councilmember Sales.
Thank you, Mr. President. I would just agree with my colleague that I do agree we need to hold the bill to await clarity in the purpose of this bill. There were quite a few recommendations that came through this working group, and so I would have thought we would have gotten at least, I guess, a longer set of bills, more of a, I don't know, a summary of the bills that they're planning to put forth, all based on the work group recommendations. And I like the idea of having someone from our staff actually vet the process, from whether it's the Planning Commission, the Permitting Department. It just seemed like the way the bill was written, that it may be a cost, unforeseen cost that we may be imposing on ourselves if we circumvent one part of the process, and an evaluation comes back and it contradicts another part of the project. So just wanted to know if there's other bills.
Yeah,
that are-
if I can just clarify, and we very much appreciate the comments made by the Council Vice President, Councilmember Sales, because Ms. Dunn did play an important role, and there were different perspectives, so it's important to hear it. I just wanted to indicate that most of their recommendations did not require state legislation. So there will be a lot you'll see working through the process that do not require state legislation. So I want to make that point.
To follow up on both your comments, Councilmember Sales and Ms. Michelson's,
Yeah.
the work group had 3 recommendations that related to state legislation.
Okay.
Those three bills are proceeding. They're being sponsored by Delegate Lopez.
Okay.
The 110 we just discussed is one of them.
And then
The
the
next
2
one,
additional.
11124, is one of them. And the one relating to state highway projects that Ms. Wenger is handling is the third.
Okay.
So those are the only 3 recommendations in the report that
Okay.
related to state legislation.
Okay.
So,
And so we'll come back to discuss this when it's rewritten, the current bill. 11024.
Yeah, when there's a set of amendments and they've been vetted,
Okay.
we'll be back in touch.
Perfect. Thank you.
Very good. So we'll hold this conversation to take it back up when it's revised.
okay, to Councilmember Sales' point, this is the third bill you'll be hearing about that's coming from the work group. This bill, it's my understanding, has been drafted correctly, although if there are recommendations from Ms. Dunn or anyone else that this does not fully reflect the work group's consensus decisions, I'm sure the sponsor is open to amendments, because that's the intent of this bill. And specifically, it authorizes the planning board to tentatively approve a subdivision plat subject to completion of certain specified conditions, and then allows for a process where the planning department could ensure that the conditions are met, and not have to come back for another hearing before the planning board, is my understanding. The concept, the actual language of the work group report I've included in the memo. The work group's report indicates that the process authorized this bill is expected to save about 3 weeks' time in the process, but not sacrifice any quality or due diligence in the process. So that's this bill. County Executive supports this bill.
Ms. Dunn, I see Director Sartori also. I don't know if either of you just want to, you can give thumbs up, I guess, that you're nodding your heads and saying that was a correct readout, so thank you. Councilmember Fanny Gonzalez.
This is a common sense approach, and I highly support it, and I hope people can also agree that streamlining things, this one will save up to 3 weeks in the entire process. It's a win-win. That's all. Thank you.
Thank you. Councilmember Sales.
Would this require any additional staff to assist with this approval, to speed up this approval?
I can't speak to that.
No.
My guess would be no, but
Okay.
Ms. Dunn may, yeah, no.
All right.
Very good. Again, common sense, reform, as we noted, and not seeing any objections, we'll support without objection.
Okay, this next bill relates to a People's Council for Land Use Planning. I'll just caveat my comments by saying I know council is much more expert on issues relating to the People's Council than I am, and council staff, but what this, and I know you're very familiar with the county code that authorizes the People's Council and the issues about it not being funded in the budget, et cetera. So I know you have a lot of expertise that I don't have. But this bill would require the county executive to appoint a People's Council. It would require that the planning board's budget, that the Maryland National Park and Planning Commission's budget includes sufficient funding for the office. It has some qualifications outlined in there for the People's Council. Council staff, I think very appropriately, you sort of asked a question about the legal validity of the bill and whether the authority given to the county executive kind of meets legal validity requirements and whether the mandate, what appears to be a mandate for sufficient funding, whether that violates really, it's an issue of really the Maryland Constitution about home rule authority for the county. And in your memo, I've included the feedback that we received from the county attorney and that they've authorized us to include in the memo. They've raised some potential legal issues and also policy issues. We note in the memo that at the time we wrote the memo and submitted it to you, the sponsor had requested an Attorney General's opinion, an opinion from the Office of the Attorney General that serves the Maryland General Assembly. Since we wrote the memo, he's obtained that AG's opinion, and we did circulate it to Ms. Wellens. I don't know if you've received a copy, but the county attorney is here if you wanted to delve into legal issues.
Thank you, Ms. Boucher. I expect a lively conversation on this topic, but I think it's important just to level set and recognize that the state of Maryland mandates a lot of different things for the counties and requires Montgomery County in particular. Off the top of your head, you, Ms. Wenger, and anyone else, can you share with us other positions, departments, or agencies that are mandated, that we actually fund here in the county that are mandated by the state? Like Maryland National Park and Planning Commission, right? That's actually a state-mandated department, right?
The three entities, I believe the three entities that we as a county interact with most are in terms that are three state agencies. They're state agencies. Our residents don't know it, right? Which confuses everything because we're just really, they want government to serve them. The fact that it's state agencies or county agencies, is kind of irrelevant. They want help. But the three agencies are Housing Opportunities Commission, state agency, WSSC, state agency, Park and Planning, state agency. Am I missing any now?
I think so. I'm just thinking of individuals like the Office of the Sheriff as a constitution.
Oh, well, we do know that the Office of the Sheriff and the State's Attorney's Office and the courts are state agencies to the extent that I know we fund the State's Attorney's Office, the Sheriff's Office, also state agencies. Was that the question?
Yeah, it opens up the conversation that there are things that we fund here and people and programs that we interact with that were actually created or mandated by the state. One other one, would the clerk of the court, would that be another agency?
Yeah, both the district court and the circuit court are state entities.
Okay. And so I think it's important to level set that because I personally feel you preluded the conversation that whether or not the state is or the General Assembly is within its legal right to pass a law like this. I personally think it is, but I personally don't think that we should have another unfunded mandate for this, and ultimately this is a budgetary conversation for the council and the county executive and the community to have. I don't think that we should go around our annual budget conversation and just have our state partners mandate a program or a policy that hasn't been able to worked through and approved in the budget process. So those are my initial thoughts. Vice President Friedson.
Thank you, Mr. President. I will note there's a difference between a state-required entity and an individual position or program within one of those departments and agencies. I'm not familiar with it being common practice for individual positions to be required within a department. Like, for instance, there's no Housing Opportunities Commission's ombuds officer that the state requires that we pay for. It certainly is a valid position, certainly something that has legitimacy, determining the salary, determining what is appropriate, makes sense, but that is far different than saying the Register of Wills or the sheriff or the clerk of the court or any of the bi-county agencies or the public housing agency in the county that's designated as such. Very, very different. There are major legal questions here. I mean, literally, if we don't fund something in a budget as a county, to have the state come in and require that it be funded in perpetuity is a very dangerous, slippery slope, which renders municipal functions almost meaningless. So regardless of how one feels about this particular position, I think this approach is a very, very dangerous approach, which really threatens the generally collaborative relationship that county government and municipal governments have with the state, and I think takes it to an extremely adversarial level, which is deeply unfortunate, and I would hope we don't continue to go down this path. This not only requires funding, this is well beyond an unfunded mandate. This also removes from the council an authority and moves it to the county executive, which is frankly a continuation of some of the challenges that we had last year that were unfortunate, and I think were not helpful to anybody as part of this process. So there are major legitimate legal questions here of whether or not this is appropriate. There is room for discussion and debate like most legal opinions, but as a policy matter, even before we get to that, and this is where I agree with the council president, this is just a very dangerous, slippery slope, which, strictly, very expressly limits municipal authority and county authority in our home rule function, and also very much strips of the county council its budget authority vis-a-vis the executive, which is something that I would think that we would hold as sacrosanct. So I would move that we oppose this bill, Mr. President.
Thank you, Vice President Friedson. Any other colleagues wanting to weigh in? Not seeing any, so Council Vice President Friedson has suggested we disapprove, not support this legislation. Any objections to that? Okay. So we oppose. Thank you for that terminology. That terminology evolves every year. Okay, so without objection, we will oppose this legislation.
Okay, the next bill is 11324. I think we might have, just in case we have questions, we might have MC Dot reps. Yeah, we do. We do have MC Dot reps if we have questions. So this bill, again, relates to the Regional District Act. It does two different things, two different subjects. One relates to loading docks and transportation planning. The issue is, as it's been explained to me, is that loading when subdivision plans or project plans, planning documents approved by the planning department that relate to loading docks in certain parts of the county, Bethesda has been mentioned to me, where projects are approved where the Department of Transportation and others, DPS and others in the community, have been concerned in the aftermath because the loading docks are not, the length is not sufficient to allow trucks in and out. So trucks wind up crossing over the sidewalk, trucks wind up parking in streets. The bill requires that the means of access for all loading and service vehicles servicing a commercial building site must be of sufficient length and configuration that vehicles do not obstruct a right-of-way, public easement, or on-site pedestrian route. Then separately, there's a part of the bill that relates to what kind of information relating to transportation infrastructure must be in planning documents. Or to put another way, what control does the planning board have over transportation infrastructure details? The bill literally, and I put this in the memo, the bill literally outlines information that must be in planning documents relating to transportation infrastructure, and information that must not be. This sort of doesn't have to be, but the bills actually must not be. So we could speak in more detail depending on your desires, but would it be helpful for me to clarify the information that should be in or shouldn't be in under the bill?
So thank you for teeing it up. The initial question I have, and is noted in the packet, is whether or not this was a recommendation from the development work group.
No, it was not.
Okay. Vice President Friedson.
Well, thanks. You got my first question. Did you consult with council staff on this or planning staff? It seems like there's a significant amount of input from Department of Transportation and Department of Permitting Services. Did we? So,
Yeah.
It very much is in the development review process. It doesn't seem like it was taken up or recommended by the consensus group set forward to deal with development review.
Yeah.
So just wondering what consultation has occurred with
I
council
did-
staff and planning staff.
An excellent question. I did speak with Planning Director Tanya Stern when we met council last time, explained to her that I would love to be able to reflect the planning board's comments in the memo. At the time, she indicated that they were still, at the time she indicated they had concerns about the bill. I have not received anything in writing from Ms. Stern. I mentioned briefly to Ms. Dunn the bill. I believe she has concerns about the bill. And Ms. Dunn, I
We can-
apologize if
we
I
can
should have
invite
had
Mr.
something in
Sartori
writing
and
today, so.
Ms. Dunn up.
Maybe we start with Ms. Dunn, and then we can turn it to Mr. Sartori.
Sure. Good morning, everyone. I don't remember communicating on this bill with intergovernmental staff. What I will note is the Development Review Process Working Group did talk about the issues that are kind of captured in this bill in some way. Primarily the ones, obviously, that dealt with development review. That was what the group really focused on. And in the case here, there were lengthy conversations about lead agency and how issues related to things like this get resolved through the memorandum of understanding and lead agency. And the development review process work group talked about that at length. And everyone unanimously decided that that memorandum of understanding is now relatively outdated and needs to be updated. And that itself is a recommendation from the development process review working group, that that memorandum of understanding needs to be completely updated and clarified, and it will help address a lot of these issues. So they're kind of, as was mentioned, two things going on in this bill. One of it is related to master planning and what can and can't go in those master plans. That is a tangent, I believe, and it is something that was slightly talked about in the work group, but definitely did not have support of the development process review working group. And then where it relates to development review, the idea was, you know, a recognition that there are concerns, there are things that are can cause challenges for both agencies, and what needs to be done is an update to that memorandum of understanding.
Mr. Sartori?
Thank you. For the record, Jason Sartori, Montgomery County Planning Director. I want to be very clear with this. We do not support this bill. And also, one thing to clarify is that the master plans are not the planning department's master plans. They're really the community's master plans, but they are the process, the result of a stakeholder engagement process that's quite lengthy, that goes through the planning department, the planning board, and ultimately it's the county council that approves that master plan. So these are your master plans that you've approved. You know, master plans without the transportation elements that are discussed in this bill would be woefully inadequate and would render the plans, I would say, somewhat useless. The bill proposes changes that run counter to best practices in the planning industry. It's kind of impossible to extricate the transportation recommendations and the elements that are part of this bill from the land use elements of our master plans. Best practices really say you need to be looking at both of these at the same time comprehensively, whether it's the standards or the metrics, the right-of-way allocations, all of those things. The land use recommendations that we have in our plans are impacted by the transportation elements. The transportation elements are impacted by the land use elements. We can't adequately implement those plans if we're not looking at those comprehensively at the same time. It's also, I would add, that it's a little unclear how this bill would render existing transportation recommendations in existing master plans. You know, we can't look to the master plans for these recommendations, then where do these standards, these metrics exist? And what would we hold our applicants to? It's unclear from this bill.
All right, sounds like there's a lot of concerns. We had a work group that was set up for a reason. It identified some of these issues, some of which I, by the way, agree with. Loading dock issues and other things in Bethesda have been an ongoing concern, an area that I would like to see us address better. There's some study of that at planning, I know, that I'm looking forward to diving deeper into. But the approach that this consensus group came up with was lead agency MOU, to bring the agencies together, to work together collaboratively to figure out how to do this. This bill seems to be a direct departure, a specific opposite direction from what the consensus of the work group was that included many of the agencies that were participating, which I think is unfortunate. I think we should oppose the bill. I'll move that now.
Thank you, Vice President Friedson. Ms. Cordova, I see you you want to share with us MCDOT's thoughts on this bill?
Thank you, President Glass. For the record, Marisela Cordova, Montgomery County Department of Transportation, Acting Deputy Director, Transportation Policy. And while I agree in general with Mr. Sartori's position and with Vice President Friedson, in a way, I would just like to clarify that, well, first of all, it wasn't our bill, of course, but I would like to clarify that the bill doesn't really preclude us from collaborating on things like Vision Zero and Complete Streets, which is the focus of our collaboration these days, as we all know. And those are critical issues that we still need to collaborate with. But rather, this bill, the way we look at it, is really addressing the issue of master plans expanding beyond the realm of planning and into things like operations and performance metrics, which DOT is actually a lot more prepared and it's more of there are more technical issues that are things that the department are more able to is more able to address than the planning board. That's really our position. That's where we're coming from.
Got it. Thank you for that. Councilmember Sales.
I guess I would just want to clarify more about the study that the planning department committed to but hasn't completed. I know that part of the bill calls for a completion of this study. Do we have a status update on? Okay.
Yes, actually, we do. So we are planning to present the findings of that study to the planning board next month, and then we can plan to come to the county council with that study in January, if you'd like. The important thing on that, I think, is that the decisions on those are those loading-based docks, that urban loading question, is not done in isolation by the planning department. It's really done in conjunction with input from DPS and from MCDOT in the development review process. But in large part, we're kind of bound by what's in the zoning code. And so if there are changes that need to be made there, hopefully the study, and I haven't seen the results of the study yet, but hopefully that study will give us some idea of what direction we need to go in with that.
Yeah, I just don't know if this bill will address that when we already have a study underway. I think we should wait for the results from the study before we make a decision on legislation to accompany this. Thank you.
Thank you. Councilmember Fana Gonzalez.
I was on the planning board when we requested this study many years ago dealing with the Bethesda site plan. And I knew that because of the pandemic, it was on hold, and I'm glad that it's going to be out very soon. There's no need for this bill, and I oppose it. Back to you.
Okay. So hearing the concerns of colleagues, and Vice President Friedson motioned to oppose the bill. Any objections to opposing the bill? Okay, so without objection.
Okay, so let's go back to Circle 1 of the packet. So we'll go back to the pieces of legislation that required some follow-up. In some cases, we do have follow-up. In other cases, we don't have a lot of follow-up. So we can run through those and see where things fall from that.
Sounds great.
And the first one is the Montgomery County Board of Education. Kathleen.
Okay, so for MC 524, on page 1, when we last spoke with the council, you had wanted some information on the Board of Ed's position and also sponsors' intent. So on the Board of Ed position, I was advised by Patty Ersprung, their government relations lead, that the board has not taken a position but is considering this bill on December 5th. So that there may be a board position on December 5th. I did communicate with Delegate Polakovich Carr about her intent, and she did confirm what I thought was her purpose, which is that to allow voters to elect positions that are normally elected positions, particularly when there's a significant amount of time remaining in the term. So the way the bill is drafted, the vacancy would have to occur before the second year of the 4-year term ends, and it would have to, and the vacancy would have to occur 55 days before the primary in the second year of this person's term. So that's what it does, sets up a special election process for vacancies on the Board of Ed, and if you'd like to discuss the bill details again, happy to do that.
Great, thank you. Councilmember Sales.
Yeah, I was just wondering if we've thought about how much it would cost to run a special election for such a vacancy. Do we have any estimated costs?
Not at this time, Councilmember Sales. The fiscal notes are prepared for local bills, but it's not prepared yet. I can check that the Department of Legislative Services actually prepares the fiscal impact statement, but gets input obviously from our county board of elections. I can certainly ask our own board of elections for information and get it to you as soon as possible. Then I can certainly forward the formal fiscal note when it's completed.
Yeah, I'm just unsure of what issue this bill is seeking to address. Have there been problems with previous appointees with the Board of Education? I can't even remember the last time we've had a Board of Education appointment, or why this is even seeking legislation to force an appointment. So
If I could just jump in, Councilmember Sales, I think you asked the right questions. After the last conversation, I called Delegate Polakovich Carr and asked for more information about this. With regard to the special elections, it's not technically a special election in the way that we think of it. It is having an election in one of the midterm or general election or gubernatorial
Correct.
election.
Right, correct.
So there will be no additional funds expended for an election to be held. And what the other idea that she shared was twofold. One, there is efforts in Annapolis to get away from appointment processes, and this would bring our school board in line with 7 or 8 other school boards in the state of Maryland that currently operate in a system similar to this.
I would be, I appreciate that, Mr. President. I would just be hesitant to support this bill until we hear the outcome from the Board of Education's discussion on the 5th.
I agree with that. Councilmember Mink.
That's exactly what I was going to say. Yeah.
Great.
That's just you hold. Thanks.
Oh, okay, great. So clearly interest, but we're very interested in hearing what the school board has to say. So we'll hold off until we hear from them.
next bill is MC 824. I'm here to say that there are no formal sponsor amendments that have come our way yet, but we have clarified the intent to say that an HOA essentially cannot prevent an ADU or a basement dwelling unit in their bylaws or deed restrictions if that property is zoned for multifamily housing.
Thank you for that explanation. Any comments? Not seeing any comments from colleagues. Does the planning chair want to comment? Okay, Vice President Friedson?
Yeah, well, let me just say, I agree with the intent of this bill in the fact that we need greater diversity of housing types. This is in line with that mentality. I will say there is a lot of engagement that needs to take place because this would be a dramatic change. And I just would make sure that we have some public conversations about this. You know, normally if the council, when the council takes up zoning changes, which is essentially what this is, we have significant public engagement. There are public hearings, we take public testimony. In this bill, we're being asked to weigh in on a bill, which again, I support the overarching intention of the bill, but without any type of public engagement. And so I just would note that. I will say there are major equity dynamics here of where zoning changes can and can't take place, what restrictions to zoning changes exist. An example would be our ADU bill, as I mentioned before, which had significant restrictions based on areas that have common ownership communities like an HOA. There are more HOAs outside the Beltway than there are inside the Beltway just because of the timing of the development pattern. It's not to say that restrictive dynamics in land use are exclusive to HOAs. They are absolutely not. But the structure of an HOA based on the development pattern, they didn't exist when much of the growth in the county inside the Beltway occurred. So I think it's important for us not to gloss over this. This is a significant state bill that dramatically would dramatically change the rights of common ownership communities to make certain requirements and certain covenants on their properties. It's a worthwhile public conversation, but one that I think warrants a lot of engagement and discussion and sober back and forth, and one that I would be hesitant for us to weigh in on for or against very quickly without any discussion or public engagement. So I just wanted to note that. I'll yield back.
Yeah, I appreciate that. I agree with the general sentiment. I know that the intention of this legislation is to address the housing crisis that we're in, and that there are certain types of properties and associations that support or hinder the expansion of housing opportunities for as many people who need it. But I think this is a very complicated proposal within HOAs and the bylaws and the way that fees are structured and other things. And so I think it warrants some really deep conversations. Ms. Boucher? I'm sorry. Oh, and I see Councilmember Balcom has her hand raised. I was looking at my texts. Thank you, Vice President Friedson. You'll be great at this. Councilmember Balcom.
So thank you, and I appreciate the conversation that both Councilmember Friedson and Council President Glass have already mentioned. I think that this is such a much broader conversation as to what HOAs are allowed to do and not allowed to do in terms of restriction. And I think that that's just a broader, more global conversation that we should have internal in the county. And I don't think I'm ready to support this legislation without having that conversation as to how it impacts our zoning in Montgomery County. I think this would be a complete surprise to our HOAs, and I don't think that they've been engaged, and we certainly haven't been engaged in the conversation. I would suggest that we hold off on this bill.
Thank you very much, Councilmember Balcom. Seeing the consensus from colleagues, without objection, we'll hold on this bill to get some more information and have deeper conversation with the sponsors and how we can work through their shared intention.
Mr. President and Council, this is MC 1024 dealing with speed limits. This bill is a rewrite of what you saw previously, where it appeared to be more requirements to reduce speed limits, and in fact it's repealing requirements having to do with engineering and traffic investigations, that now that's not going to be needed. The county executive supports this bill with an amendment to allow a one-year moratorium on the placement of speed cameras on roads where the speed limit was reduced. When we got the authority, when local authority was granted to reduce the speed limits, the state had included a outright ban on putting speed cameras in on those roadways. And in discussing it with the county executive, the concern with not being able to have speed cameras is then you would really have very little effort to enforce lower speed limits. It just would become a lot more difficult. So the county executive supports this bill, and it's, as I say, it's different from what had been previously presented.
Thank you, Ms. Morningstar. Councilmember Mink.
I think that we should support the bill as it's presented now, and appreciate the D20 team for their consistent support of this type of initiative and working towards our Vision Zero needs. And I think that the county executive's amendment makes sense, that a full ban on cameras is not what we want. So a year seems like a fine compromise to me.
And it seems that the 1 year is so that drivers get used to the change, right? An educational period, presumably.
I believe that's the intent.
And my understanding is also that WABA supports this bill.
Very good. Vice President Friedson.
Yeah, I appreciate the clarifications, also the recommended amendment from the county executive. Agree. I'll just note that the year is standard practice now. So this is basically codifying what is the standard practice, for the reason that cameras are supposed to be an enforcement tool, but not necessarily a money grab. And that has been the repeated concern that you hear about cameras, that this is just a money grab, when in fact it is one of the strategies to address speeding, which is the #1 contributor to safety issues, major collisions that result in significant injuries and death. So I second it, agree that we should support, and appreciate the fact that we took the time to get the clarification.
Great. Appreciate, as noted, the District 20 delegation hearing our concerns after the last session. This is the way that I know we all hope these conversations go, that we talk to each other, learn from each other, and improve some of these proposals. So without objection, we will support this legislation.
Thank you.
Okay, this next bill, 1224, relates to the state's attorney's office, and it would impose the county's personnel law on certain employees in the state's attorney's office, as well as create collective bargaining rights for certain employees. When we last spoke, a number of questions were raised about the complexity of the bill, and my understanding was that council members wanted more time to reflect on the complexities. In addition, I want to note and apologize, the memo that, well, let me step back. This bill, like I said, does two things. Imposes the county's personnel laws on some state's attorney's office employees, and creates collective bargaining rights. At the time that I last spoke to you, I had spoken with the sponsor, and he had explained the intent of this bill was to create a model like the model that now exists in state law for the office of the sheriff, where the county executive is the employer for the purposes of compensation and fringe benefits, and the sheriff's office is the employer for purposes of working conditions and everything else. And in my prior memo, I had noted the fact that the language in the bill is very different than the language in state statute for the sheriff's office. The language in this bill is rather skeletal, and the language in the statute for the sheriff's office is very detailed about how this would be implemented. More specificity about employees that would be covered, specificity about what happens if there's a conflict between a collective bargaining agreement and personnel regs, managerial authority that still exists, that kind of thing. I apologize, but it inadvertently dropped out of this packet. With that background, there have been subsequent discussions. I've had subsequent discussions with the sponsor, Gina Wren, president of McGeo, who requested the bill and has been working with the sponsor. They have, McGeo's lawyers have clarified that the actual language in the bill, it literally mirrors language that's currently in state law for the Prince George's County State's Attorney. So this language that's in this bill, and I kind of reviewed it word for word, is almost exact in terms of the Prince George's County State's Attorney's Office, which has been in effect for a number of years. So the actual statutory language was modeled after that. In talking with the county attorney's office and the county executive, regardless of what the language is, regardless of the skeletal language, Montgomery County would have to figure out how to implement this bill if it passed. And essentially, it's calling for a sheriff's model. You know, this situation where the county employer is county executive's employer for one set of things and the state's attorney for another is a model that would require a lot of specificity, in talking with the county attorney's office and talking with our labor relations administrator, just to figure out how it would work. That's why there's specificity in the sheriff's office statute. So again, that's the background I have on the bill. The county executive supports the concept of the bill, but also has asked the county attorney to flesh out legal issues and it has asked for help. And is there anything that needs to be in the bill for the county to be able to implement it?
Thank you. Councilmember Sales.
Thank you. I just had a question about the collective bargaining laws. I know that we needed additional information about yes. Let me see. Wait. I yield. Let me come back.
Okay. Councilmember Mink.
Thank you. Appreciate the additional information. And in my conversations as well, I'll just say that generally expanding the right to bargain, I think, is a good thing. It's something that is a forte here in Montgomery County, and finding ways to improve and strengthen our labor laws and to represent more folks. The benefits of that are broad-reaching, and so I appreciate Senator Kramer for bringing this, for working with McGeo. I understand that both the support staff and the attorneys there would like the right to collectively bargain, and so I would suggest that we support this bill as well, and but also standing by for potential amendments that might be needed to address legal issues or implementation issues. But I think it would be great for us to make clear that we would like for this to happen.
Thank you, Councilmember Mink. Just to go back to what the county executive's position is, if I heard it correctly, it's support the concept but wait for it to be fleshed out a little bit more?
Yeah, to support the concept and knowing that it needs to be fleshed out.
Great. And personally, that's where I would be as well. Councilmember Sales.
Thank you. So fleshing out, would we have to go into a work study group to review the current regulations within the sheriff's office? Are we duplicating those? What would that process look like if we were to support this bill and it passes?
Well, I think you're asking exactly the kinds of questions that need to be answered, but I would have to defer. These are exactly what needs to be answered. This is why I'm talking with the county attorney's office, with our labor relations administrator, to see what needs to be added. And if you're asking, does a work group need to be established, I defer to others on that. What we would do is work with our exec staff in the county attorney's office to develop proposed amendments and bring them back to you.
Okay. I mean, I think this could be, we're always looking at ways to attract and retain new staff, and job security is really important. And so allowing staff in this particular office to be able to collectively bargain hopefully will be seen as a plus and a benefit. And so just curious to see how what this will look like in practice.
Councilmember Katz.
Thank you very much, Mr. President. I, too, am where your position in the same place, though I do believe the county executive has said that we should ask the county attorney to review the bill and make recommendations. So the question is, what comes first, the chicken or the egg? We probably should wait for the suggested amendments before we support the bill, but I'm certainly supportive of the concept. And wait, we have a county attorney.
And you asked for Mr. Marcos, and he appears.
So the position that at least I've taken initially is that we need to match up against the sheriff's legislation, the way the sheriffs were built into the system for collective bargaining. As it's written right now, there are lots of defects in the legislation in terms of implementation. So if the model follows the sheriff's model, that the bill follows that type of paradigm, we shouldn't have a problem being able to bring them into collective bargaining. And I did have a conversation with Mr. Wren about it and reiterated the fact that I believe that it needed to follow the sheriff's model. So when you ask me about amendments, it really needs to go to Ms. Boucher's position, which was, if you look at the legislation, it's skeletal. It needs to be fleshed out so that we can properly implement it with our collective bargaining agreements, our grievance process, our merit system protection process, which they differ from Prince George's County.
Thank you, Mr. Markov. So from everyone who's spoken on this issue, there's clearly support for greater collective bargaining rights, and we want to make sure that the legislation fits into the various models here and is workable. And so we'll hold until we get some better clarity from the sponsor, or if our county attorney's office is able to flesh that out. Is that right? Right. Okay. So without objection, we'll hold.
Okay. This next bill, MC 1324, when we discussed it last time, this is the bill that gives the Circuit Court in Montgomery County, the chief administrative judge in the Circuit Court in Montgomery County, to create a truancy reduction in school re-engagement program. And I could walk through the details again if you'd like. When we last spoke, there were questions about the Board of Ed's position. I know I had questions that I think I reflected about the court's position. There were questions about how this bill would be implemented, and I reached out to the sponsor, Senator Nancy King. I spoke to Board of Ed reps, and I spoke with Judge Kathleen DeMay with the Circuit Court, or communicated with her, and MCPS staff. I'll just note that one of the things I learned in talking with MCPS staff is that there was a briefing recently here at council. There was an 80-page council staff packet on truancy-related issues, and so that was a briefing, Public Safety Committee and Education and Culture Committee. So I know once again, you have a lot of in-depth background that I'm catching up on. Judge Dumais indicated that the circuit court supports this bill. She was available as a resource to discuss anything about how it could work. MCPS staff, again, MCPS staff can't take a position, but they were very helpful in providing links to the council packet, links to the current truancy policy at MCPS. Again, as I mentioned earlier, the Board of Ed is meeting on December 5th to consider some bills. I think this bill is going to be one of them. So happy to answer any other questions as best I can.
Sure. Thank you for that. I'm going to assume that since we've deferred to the Board of Ed on some other issues, if they'll take this up, I'm sure we'll be very interested in what they recommend as well. But do you know how this would interact with the truancy prevention program, which is formerly known as the truancy court program, which is run by the state's attorney's office?
You know, that is a key question that I posed when I learned from Judge Dumais that the state's attorney's office does have a program. I reached out to Robert Hill, who's our legislative liaison with the state's attorney's office, and asked him that very question. I only learned about the state's attorney's office when Judge Dumais told me, and I sent the email to Mr. Hill before Thanksgiving. I have not heard back, but that jumped out at me immediately, Councilmember Glass.
Yeah, my understanding is that the state's attorney's program has been around for more than a decade and has been doing a lot of good work, and so we don't want to clearly redouble efforts or whatnot, but we can all reach out to members of the Board of Ed. If they're not aware of the truancy prevention program, we can bring it to their attention and see what their thoughts are. Councilmember Mink.
Thanks, I agree with that plan of action. And I would also note that we have a lot of diversion options at our disposal that we could be using more of and funding up more of, as we've been discussing. The Maryland judiciary has established that best practices generally are using an independent organization, which it's tied to the Justice Reinvestment Act as well. So, I right off the bat have some hesitancy around going in this direction when we think about where we want to spend our resources. That said, withholding judgment on it. But I will note that I've heard from several sources that it could be helpful to fund a teen diversion coordinator, because given the timing, cases need to move quickly. If someone's going to go through diversion, it needs to get there quickly. But given that staffing is difficult, often those cases aren't being reviewed until we're reaching kind of the end of the time limit. So having somebody who is at the front end and looking at cases right off the bat as they land on the desk to say this is a good option for diversion and sending them to an appropriate community-based program, that's something that could have a very tangible impact right away, no matter what diversion programs we want to use. So I want to note that, and if that's something that Senator King might want to consider as an alternative, depending on what direction this goes, I think that they might see some support from their colleagues as well.
Great. Thank you. Councilmember Katz.
Thank you very much, Mr. President. I'm in agreement. We should hold this. I think it's something that makes a lot of sense. We did receive an 80-page document not too long ago from Education and Culture and Public Safety. I do believe that we need to make certain that the state's attorney's office does give us an answer as to where they are in this process. And to Councilmember Mink's point, I mean, we certainly don't want to duplicate, but we certainly want to improve, if it's possible, what we're doing. Having said all that, I would hope that they don't put in this legislation mandating that we hire somebody. If the departments believe we need to hire someone, we should be able to do that without them mandating it, because they might mandate it, but they're not sending us any dollars. So, however they're working this. Thank you, Mr. President.
Councilmember Sales.
Thank you, Mr. President. Just had, my colleagues have brought up really good points, because we've all heard about the increase in truancy related incidences in our school. Just would love to know about, I think, all the programs that we're currently funding. Another program is the CINS program, the Child in Need of Supervision, that will direct students to holistic services, social services. And so we have a lot of programs that we're currently funding, but not a lot of data on what the impact of those programs are, and to come up with something else without fully evaluating what we're currently responsible for and its impact on reducing the truancy-related issues, and how impactful these programs are with re-engaging our students back into their school community. I think we should start there, and it sounds like that's what the county executive recommended as well. Thank you.
Thank you. Councilmember Alvarez.
Thanks. I agree with everything that's been said, not to beat a dead horse here, but just to underscore, this is a huge problem. We had the joint committee session, and this, along with the reading scores and the reading proficiency scores, are just raising every conceivable red flag there can be. And so it does require an all-hands-on-deck approach, and so I certainly appreciate very much the intent of this particular bill. Agree that we absolutely need to hear from the Board of Education, and would request that when they provide their response, not just comments specifically on this bill, but how or if any other potential legislation might be helpful to them in trying to address what we've all acknowledged as a crisis.
Thank you, colleagues, for all those thoughts. So we'll hold onto this legislation. Look forward to hearing the outcomes of some of those conversations.
Thank you.
And that brings us to one last item this morning.
That's right, this is the last one, and this is revisiting, this is a development review work group consensus concept that, as the bill was drafted and introduced, did not reflect, I think, what the work group had intended. And the intention was to align the State Highway Administration process with the development review process as far as providing comments on applications. So this, I just cut and paste in the set of amendments that I believe the sponsor will introduce tonight, and I do believe that they are consensus work group amendments now, based on conversations with Ms. Dunn, and changes that were also included in these amendments from Capital Park and Planning, and then also general agreement from the executive branch side that they reflect what the consensus was of the work group. It's just that the bill initially didn't do that.
Ms. Dunn, Mr. Sartori, Ms. Dunn, if you could just come on up.
Thank you. Yes, I was just conferring with our staff at the planning department who've been working closely to make sure that the amended language reflects what the work group has consensus agreed to.
Very good. As we support the work of the work group and make sure the legislation accurately reflects, we'll support this without objection.
That's it.
That's it for now. And just for everyone's understanding, the delegation will be meeting tonight, right, virtually, I believe, to review these, and OIR, OIG, OIR. There we go. Will accurately reflect out the areas where the council and the county executive have consensus in the bills that they support, and look forward to hearing back on some of the ongoing legislation and legislation that is yet to be introduced.
That's right, and I would just note too that on the agenda it identifies which bills are being heard, which one of the two hearings. So there's also a public hearing will be held on the 4th. That'll be the last of the local bi-county bill hearings.
And that is on the delegation's website?
That's
I
right.
believe. Okay. Very good. Well, thank you, everybody, for this work. We'll see some of you virtually tonight, and we are adjourned this afternoon. Thank you.